two really bad things that can happen to you. And those two bad things can affect you legally, and they can affect your family legally, adversely or not adversely, depending on how you prepare for those two bad things. And those two bad things are you can either become incapacitated or you can die. Now, first, let's talk about if you're incapacitated and the potential concern there. Let's talk about that one on the right at first. That's the reason that we're doing planning, that we are thinking about this now, because one option for who can handle my legal affairs if I become incapacitated and I can't handle those for myself is a guardian, a court-appointed guardian. A court-appointed guardianship in legal parlance is a nightmare. That's the legal term for it. It's a nightmare. You want to avoid it. You want to avoid it if you possibly can, because it is very expensive. It is very time consuming. It is a mess that you want to avoid. The court controls everything. There's additional attorneys, like an attorney ad litem, that will be appointed. They cost money. There's nothing good about a guardianship. So everything we do in planning for incapacity is planning to avoid a guardianship. Now, if you don't lack capacity, you control your own destiny. And that's the part on the left. In the middle is where planning takes place. There are two options for handling your financial affairs. Well, let me put it this way, most of your financial affairs. One is to appoint an agent under what's called a power of attorney, a document in which you appoint an agent who has legal authority to act for you, just as if you were the one entering into that transaction. They can open checking accounts for you. They can close checking accounts for you. They can write checks. They can invest in investments as Jeff would advise them to, all on your behalf. And how is it set up? Well, there's two ways it can be set up. It can be set up as something called a durable power of attorney or a springing power of attorney. A springing power of attorney says, I'm good. You don't need to be around, agent. And you do not have authority to act for me, agent, unless and until I become incapacitated and a doctor certifies that I'm incapacitated. The other is a durable power of attorney. I tell my clients that means that this person is effectively your agent as soon as the ink dries on the document. Immediately, they can act for you. You really want that power of attorney to be effective immediately. You want fewer roadblocks in the way of your agent. An alternative is a revocable trust. A revocable trust is a document in which you are your own trustee, you're your own beneficiary, and the trust owns your assets, you don't. And the advantage of that, I have found, is that financial institutions, for some reason, are a little bit easier to work with when they know about the trust in advance, the trust account's already been set up, they know who the successor trustees are. It just seems to make for a smoother transition. So I'm a big fan of revocable trust, not to avoid probate, which we'll talk about in a few minutes, but because it makes it easier to deal with your incapacity. We want to avoid those roadblocks in the way of your agent handling your financial affairs.